Thank you, Your Honor.
Oh,
Good morning, Mr. Clay.
Mr. Lang.
Morning.
Mr. Clay, how long have you known Miss Waits?
50 years,
50?
about.
Can you explain to the jury what the word loyalty means when it comes to your practice of law as an attorney licensed in the Commonwealth of Kentucky?
Well, you have a duty of loyalty to your client.
And what does the duty of loyalty entail? Can you kind of explain that a little bit to what that means to those of us that may not know?
Well, your client consults you about matters that they many times don't care to have publicized, so confidentiality is one of those duties. Loyalty requires you to represent the interests of the client, not of someone else. And if there's a lawful way to do something that the client asks you to do, then you can either do it or tell them you got to find another attorney.
And who was your client in this instance?
Are you talking about the
The instance with the power of attorney in February of 2010, who did you represent?
Geraldine Waits?
So your duty of loyalty was to Geraldine Waits.
Yes.
Did you have any duty of loyalty to Ann Rush?
No.
You said that you drafted the power of attorney at Miss Waits' request.
Yes,
You said you spoke to her in person at your office.
I did.
Do you remember how she came to be in your office? In other words, did somebody carry her into your office and put her down in a chair and then leave? Or how did she come to be physically in your office?
She negotiated the stairs outside my office. I mean, my office is on the second floor of the building, and she got herself up the stairs.
Now, we've heard testimony from a caregiver or a nurse, an RN, who was in her home later that day and met with her sometime after she had executed the power of attorney in your office. And that nurse told us that she was able to verbally acknowledge understanding of what the nurse had done that day. But the nurse testified that her ability to verbally acknowledge her understanding was pretty much to say yes, that she understood. What is your experience on February the 23rd of 2010 with Miss Waits' ability to understand what she was doing?
Well, I'd known her for a long time. She was becoming a bit physically frail, but she seemed to have all her marbles. To me, we talked about a lot of stuff. We talked about family briefly. We talked about the division of the property that she had asked for deeds to be drawn for. And I told her that I couldn't do anything with the survey, and the surveyor was not moving real fast.
Now, on the note with that survey, did you ever talk to Leslie Pointer about the survey or the deeds?
I don't recall doing so.
Leslie Pointer testified that she actually hired the surveyor like in 2007 or 8 or something. Do you know anything about that?
I don't know. I just know that that was the surveyor that I understood was doing the survey was Kendall Wise.
And Leslie Pointer testified that her grandmother wanted to divide the property for the granddaughters. Is that consistent with what you're telling us Miss Waits wanted?
Yes.
Was she lucid when she was in your office that
Yes.
day?
Yes.
Was there Did she appear to you to be confused about why she was there or what was going on?
Not at all.
Did she appear to you that she had been deceived by anyone about what was going on?
Objection.
Basis?
Calls for a conclusion of a complicated mental status, deceived.
Asking him about his observations.
I think
Your
he
Honor.
can talk about a personal observation that occurred at that time. I believe he can do that. Objection's overruled. He can ask.
There was no deceit practiced on her in my office or in my presence, ever.
Okay, now, this is a good time for me to ask you this because of what you just said. If I told you that for the last 3 days, the Commonwealth prosecutors have been implying to this jury that you're in some kind of cahoots with Ann Rush to do this power of attorney for Geraldine Waits so that Ann Rush could take all of Geraldine Waits' money, how would that make you feel?
It's disturbing that
Is it true?
it's crackpot. It can't be based on any evidence that I've seen or heard of because I didn't have any sort of collusion with Ann.
Your loyalty was to Geraldine Waits.
Correct.
And you did what she asked you to do and instructed you to do as her attorney.
Yes, I did.
Now, you said that you was not aware that Miss Waits had been diagnosed with mild Alzheimer's or mild dementia at some point prior to her coming to your office in February of 2010. You were not aware of that.
I was not aware of that.
Would that have mattered to you?
I might have observed her more closely than I did, but I observed her pretty closely and at closer range than we're sitting today.
And when someone comes into your office to do a power of attorney, is that the only power of attorney you've ever done?
No,
You've done a lot of them.
I've done a lot of them.
And is it your practice when someone comes in to execute a power of attorney that you have them bring their medical records with them so that you can review their medical records to determine what they were diagnosed with in their past
Never.
or present?
No, it's not my practice.
You base your perception of them and whether or not they understand what's going on based on your observations and your conversations with your client, correct?
That's correct.
In this case, you had no reason whatsoever to believe then or now that Miss Waits did not know exactly what she was doing.
None.
And may I approach the witness?
Yes, sir.
These documents, these power of attorney documents that have been admitted into evidence, one of which contains the notation that you prepared this. Do you agree with me that somebody could easily have covered this up and made a photocopy of this and arrived at this document? This preparer,
Correct.
this
Yes,
notation right here where you prepared it, that's what you were
Yes.
talking about earlier, correct?
Yes.
This notation does not appear to be on the copy that the Commonwealth has produced. Rather, in that same location, there is a stamp indicating that it was filed at the Boyle County Clerk's office. Correct?
Correct.
Now, any person could have made a copy of this document and covered that up, or put a sticky note on it, or put anything and created one without that, correct?
Correct.
But you didn't do that.
I did not do that.
And you don't have any idea who did or why this document here does not have that stamp on it.
I do not.
Are power of attorneys required to be filed at the county clerk's office?
Only if they're going to affect title to property.
If
some
the
fashion.
attorney, in fact, is going to convey property for the principal, the person that signed the power of attorney, then that has to be recorded at the county clerk's office, so the county clerk knows that that attorney, in fact, has the legal authority to do so, correct?
That's correct.
And
For it to be, my understanding of recordability, it's supposed to, if it's prepared by an attorney, it's supposed to be so marked, and that's why that notation is on there.
that you prepared, because
That I
that's
prepared.
required to be on there. And in fact, your understanding is the county clerk is not supposed to even file a power of attorney if it doesn't have a notation telling who prepared it on it. Is that true?
That's my understanding. They're not supposed to. It doesn't, I don't believe it destroys the validity of the instrument, but it shouldn't have been accepted for recording in that form.
Okay. Did Ms. Waite say anything to you on February the 23rd that led you to feel like she had been misled by anyone?
No,
Did she appear to you, from your observations, to be afraid of anything?
no, she was cheerful.
Did she appear to be intimidated by somebody? Like there was a bad person out on the sidewalk or in a car waiting for her to come out, and if she didn't do exactly what that person sent her in there to do, that she was going to be in danger when she left your office?
She was cheerful. She was happy. She was the Ms. Waits that I'd known for years, decades. Not moving quite as fast, but her mind was still sharp, it seemed to me.
Now, in addition to preparing the deed for Ms. Waits to convey the property to Ann Rush, you said you also prepared a deed to convey the remainder of the property to Leslie Pointer.
That's correct.
And did you prepare that and give that to, deliver that?
Yes, I did.
When is a deed, if you prepared a deed for me, when does that deed become effective? In other words, when does the person who is receiving the land on the deed legally become the lawful owner of that land?
When the signatures are affixed by the grantor, the person who's making the deed, and the person who's receiving the deed accepts it,
Delivery.
that's delivery.
And the deed becomes effective upon delivery.
Correct.
So it's possible that you could give me an acre of land that you own here in Danville. You could prepare the deed, sign it for me, I could sign it, you hand it to me and say, here you go. And that becomes my property. Once you hand me that deed and it has been executed by both parties.
You don't really even have to sign it except for recording purposes.
Okay?
All you have to do is accept it.
Okay? So you agree with me that a deed does not have to be recorded in order for it to be valid?
That's my understanding of the
I could
law,
put
yes.
that deed in my safe and keep it for a year or two, and I still own that property, even though the county clerk's office may show that someone else owns it, that you still own it, for example.
Correct.